All right, good afternoon, everybody. Welcome to the House Environment and Transportation Committee, Wednesday, February 5th. We will start with House Bill 344, Delegate Stein, Maryland Environmental Service, Membership of Board of Directors, alterations.
Thank you, Mr. Chair. Can I have my panel?
Of course.
Good afternoon, Mr. Chair, Madam Vice Chair, and committee members. House Bill 344 deals with the Board of the Maryland Environmental Service, or so the acronym is MES. It would remove the state treasurer from the MES Board of Directors and replace that position with the Secretary of the Department of Planning. And with me are my right is Treasurer Davis and Dr. Charles Glass, who's head of MES. So they'll be talking shortly. And just to give you some background on this change, the chair back in 2021 had sponsored legislation called the Maryland Environmental Service Reform Act of 2021. And as you may recall, that legislation restructured MES's Board of Directors and procedures following the revelations of actions of the prior executive director. And part of that was to restructuring the Board of Directors. And one of those changes was the state treasurer being added to MES's board. And in 2021, the treasurer was Nancy Kopp, and she joined the board. Treasurer Kopp retired in late 2021, and then Delegate and Chairman Derek Davis was elected by the General Assembly to take her place as treasurer. Then in 2023, serious issues with the management of the 529 College Savings Program emerged. And we as the legislature realized that these were major issues that required the focus of an important statewide office, and so we transferred management of the 529 program to the treasurer's office. And, shortly after the legislation passed, the treasurer and his office had developed a plan to ensure the stability of the 529 program, but the time and resources needed to manage the program have had a significant impact on the treasurer's office resources. So this bill provides a solution that will assist both MES and the treasurer's office by replacing the treasurer on the MES board with the Secretary of Planning. And with that, I urge a favorable report and would like to turn things over to our treasurer.
Thank you. I was looking at Delegate's testimony because it sounded like mine, and I was like, did he get a copy of it or something? Thank you all very much. In a nutshell, what Delegate Stein said is correct. That the duties and responsibilities of the office with 529, and in no way is that a complaint, it's just a reality. It wasn't just fixing that immediate crisis. It requires a lot of ongoing attention from myself and the staff. In addition, when things changed over and the former comptroller left and so forth, I became chairman of the Board of Trustees for the retirement and pension systems. And that, as well as we're trying to make some improvements there in our asset allocations and so forth, that's requiring, we have a very invigorated board now with some new people that we've added, and that's taking a lot of our time as well. And so what I didn't want to do, because I know MES, they require, time as well to complete their mission, and, things such as quorums to be able to do business is important. So when we started talking about it and they mentioned the Secretary of Planning, we thought that would be consistent with what they do. So when they mentioned that, I told them I would be on board and I would support it, and I would come here and lend my voice to it as well. So hopefully that capsulizes why we're here today. But they do a great job over at MES. I do want to say that, and certainly they're worthy of whatever support and attention that we can give them. And I just think at this point in time, given what's on my plate, the Secretary of Planning may be a better fit at this point in time.
Thank you. Good afternoon, Chair Corman and Vice Chair Boyce. Great to see you again. My name is Dr. Charles Glass. I'm the Executive Director of the Maryland Environmental Service. I'm here today to fully support House Bill 344. I want to thank Delegate Stein for sponsoring this bill. You have a written testimony, so I'll be brief. The MES Board is in place as the governing body for MES. I serve at their pleasure with the consent of the governor. MES is a non-budgeted independent unit state of the government. Of state government that gets operating revenues from contracts with state and local governments. In order to proceed, the board has to approve those contracts. My authority is limited in what I can approve in a non-emergency situation, and it requires five of our 7 voting members to be present and to approve any item. At times, not just the state treasurer, but lots of our board members are professionals that are in environmental engineering or in law or in finance, and they have conflicts. So we have very precarious situations when we don't have, and it's only happened once, but we really do need board members to be present to execute our contracts. Mr. Chair, we hope you will all agree that given how much the circumstances have changed since the passage of the MES Reform Act of 2021 under your leadership, that time hasn't eroded the requirement of oversight. However, we believe that this would be appropriate with the sustainability program that the Secretary of Planning runs and the current Secretary's engagement in lots of boards that deal with the environment in our state. So with that, I urge a favorable report, and I'm happy to answer any questions you may have.
Great. Thank you all. Mr. Treasurer, we're going to propose more bills that include you, so we get to see you visiting ENT. Great to have you here. I think we have a question. Delegate Stewart.
Thanks, Mr. Chair. Great to see you, Mr. Treasurer. Good to see everyone. Thanks for coming. Just a very quick question. I looked in the bill file, and it doesn't look like we have any testimony from the Planning Department, and I don't think that they've signed up to testify today. Do you all know their position?
They testified when we were over in the Senate earlier. They testified with us in favor of it.
Perfect. Thanks very much.
Any further questions? Okay. Thank you all very much.
Thank you
That
all.
concludes the bill here on House Bill 344, but Delegate Stein, don't go anywhere. We're going to turn to House Bill 131, Environment Bay Restoration Fund Septic System Upgrade Program.
Thank you, Mr. Chair. Can I have my panel join me?
Of course.
Thank you, Mr. Chair, Madam Vice Chair, and committee members. This is my first appearance this year in the role I inherited from Delegate Lafferty as Mr. Septics. So this is the first of 2 bills, and this is something, this is legislation that MDE had recommended, had requested, and so they were here, as you'll see, to answer specific questions about the legislation. I will say that there have been amendments that have been agreed to with the advocates, and Alex and Lee will be able to talk about those. Just as background, the Bay Restoration Fund was, as I'm sure you all know, was set up in 2004 to provide financial assistance for wastewater treatment plant upgrades, septic system upgrades, sewer connections, as well as cover crops. So this bill would make 3 changes to the septic system account within the BRF. And again, these are changes recommended by MDE. Under current law, septic system funding under the BRF, it places top priority on failing systems located within the critical area. This bill would make failing septic systems in an 8-digit watershed with a total nitrogen effectiveness score of 9.24 or higher the next highest priority. And again, I'll defer to the MD representatives to explain the details on that specific definition of nitrogen effectiveness. This is a change that follows a recommendation in what has come to be known as the Caesar report. This was a report that was issued in 2023 by the Chesapeake Bay Program's Scientific and Technical Advisory Committee that looked at what is working in our progress to achieve water quality goals in the Chesapeake Bay and what is not. So this is one of the recommendations for improvement. The bill would also make moderate-income homeowners eligible for the cost of repairing or replacing a failing septic system with the best available technology. Currently, they are not eligible. Moderate-income homeowners are not eligible. And so finally, the bill replaces a static eligibility date for certain projects. One of the eligible funding uses under the BRF septics account is for connections to failing septic systems to a municipal wastewater facility or the establishment of what's called a community sewage facility, pulling together a number of septic systems. When we passed legislation that established eligibility for these kinds of projects, it only applied to septic systems that were installed on or before October 2008. It's now 2025, so this date is starting to exclude homeowners whose septic systems have reached the end of their natural lifespan, but who currently under the 2008 date would not be eligible. So the bill addresses the issue by having a rolling eligibility date for septic systems installed at least 15 years before July 1st of the application year. So with these changes, the septic system account of the BRF will continue to help improve water quality and reduce nitrogen throughout all of Maryland's watersheds, and especially the Chesapeake Bay. So with that, I urge a favorable report.
Good afternoon, Chair, Vice Chair, and members of the committee. Alex Butler representing the Maryland Department of the Environment here in support of House Bill 131. I'd like to thank Delegate Stein for bringing the bill forward. MDE supports House Bill 131, because it makes several key updates to the Bay Restoration Fund that will help expand the availability of funds to more failing septic systems in need and help improve nitrogen reductions. So the fund has the critical area, as the delegate mentioned, as a #1 priority for funding disbursement. We are seeing failing septic systems in areas outside of the critical area worthy of priority, and we would like to expand the priority to systems in other challenged watersheds. The original draft of the bill has the term nitrogen impaired watersheds. After some further discussions, we feel that allowing areas within 8-digit watershed total nitrogen effectiveness score of 9.24 or higher is the science-based approach that expands BRF options to additional but clearly defined areas. The expanded but targeted approach is based on that Caesar report, which you have heard mentioned many times throughout your briefings. The bill also expands financial assistance to moderate income homeowners for upgrades and maintenance that in many instances, they would not be able to pursue due to cost. Finally, the bill changes that outdated provision in the BRF that, when originally created, limits eligibility systems, that rolling deadline. So House Bill 131 would change that to 15 years before the application for funds is submitted. We have some amendments which we've agreed to with other interested parties after testimony submission deadline, so those aren't going to be in your packet, but we will get those to you. What they do very briefly is they clearly define what we want is to target the nitrogen effectiveness by the Maryland 8-digit watershed code. That's a science-based approach that expands funding priority to the most deserving areas. We're also amending out the pay for performance provision with the understanding from the industry that we'll revisit the concept at a later date. So altogether, we achieved several objectives here, and we ask for a favorable report on House Bill 131.
Please go ahead.
Yes, good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. Lee Curry, I'm the Director of the Water and Science Administration at Maryland Department of the Environment. It's good to see everyone. I'll keep my comments brief. One, this expands upon an already successful program. I think what this does is bring the science to bear onto how do we more effectively spend the state's dollars. The science-based approach, it's been around for some time in terms of how we look at where the most effective areas are in the watershed. We've used it in other programs, and I think applying it here makes a lot of sense. My role here today is just to make sure if you have any questions related to how this works, I'd be happy to answer them. And again, I'm looking for a favorable or want to support House Bill 131. Thank you very much.
Great, thank you all. Are there any questions? Delegate Jacobs.
Thank you, Mr. Chairman. couple times in the fiscal note and other places, Delegate Stein, or either one of you can answer this. It talks about operational impacts on local health departments. And I'm just wondering if you have any comments on that, because there seem to be, at least in my district, pretty stressed as it is, trying to get permits out and get things done between MDE and the local health departments. So can you tell me what that means and what's written in the fiscal note and whatnot when it comes to, like I said, operational impacts on local health departments?
So I'll take a shot at this, Delegate Jacobs. So I see the note here from the Maryland Association of County Health Officers. That's likely referring to the pay for performance or the performance-based funding. We've eliminated that from the bill.
You've taken that, is that amended out?
That's amended. That's going to be amended out of the bill, yes.
All right, thank you.
Any additional questions?
And you said you had.
Sorry, Delegate Jacobs, I didn't realize you were still going. Please go ahead.
Amendments. I see there were quite a few people testifying with favorable amendments. So some of the amendments you mentioned early in your testimony satisfy some of the amendment requests by those that are going to testify after you?
Correct. I'll let them speak for themselves, but we believe we have an agreement on the reprint as we've amended it.
All right, thank you.
Okay, any further questions for the sponsor of this panel? Okay, thank you. We have one other favorable witness signed up in person, Paul Ellington. Please go ahead when you're ready.
Well, actually, sir, I was supposed to be signed up in opposition.
Well, you're there, so let's just get the opposition out of the way. Go ahead.
Thank you. My name is Paul Ellington. I'm here on behalf of Worcester County, and we're waiting to see some of the amendments, but one of the things that we wanted the committee to be aware of as a whole is the goal in Maryland is to increase housing, especially entry-level workforce housing, and we see this as a direct inhibitor to new housing that we have to do. It's not big developments. A lot of it is workforce. And we'd like to work with the sponsor to make him and others, you know, maybe consider some of our thoughts because we have some comments. But in Maryland, not just on the Eastern Shore, Western Maryland as well, even in the district suburbs, you can move out of state and not change anything but your commuting pattern. And on the Eastern Shore, Worcester County in particular, we have people moving to Appomattox County in Virginia and Sussex County in Delaware. And those folks are forever lost. And if we're going to grow our way out of the housing shortage, we really need to reduce the cost of housing. And this is one of the ways we see it as possible. That's why we stand in opposition. Thank you.
Thank you. Any questions? Okay, thank you very much. We'll call up favorable amendment witnesses: Emily Ranson, Clean Water Action; Annie Richards, Shore Rivers; Edward Harrison, Maryland On-Site Wastewater Professionals Association; and William Castelli on behalf of the Realtors. And just a reminder to these witnesses and everybody waiting to testify, try to get close to the mic that you're speaking into because it's actually quite hard to hear up here sometimes. So try to project and get close to the mic.
All right, I can go first. Good afternoon, members of the committee. I am Emily Ranson with Clean Water Action. Formerly favorable with amendments, we are now favorable with the amendments that MDE is going to be submitting. Between submitting our testimony and this hearing, we've worked out amendment language. We really appreciate the new maps that they are creating with their new definition. And we really appreciate the work that MDE has put in addressing our previous concerns and suggestions on the bill. So thank you, and we urge a favorable report.
Oh, thank you. Well, good afternoon, everyone. I'm Annie Richards. I'm your Chester River Keeper with Shore Rivers. Shore Rivers is a river protection group on Maryland's Eastern Shore with more than 2,500 members. Our mission is to protect local waterways through science-based advocacy, restoration, education, and engagement. We were also formerly favorable with amendments, now favorable with the amendments supplied in your sponsor packet. You know, me too, for everything that Emily just outlined. I'd just like to take a moment to highlight some of the important points of this bill and how they impact the Eastern Shore. The critical area, I'm a huge fan. You've heard me testify in support of many things related to the critical area. And what is special about this bill is it starts to take into account elevation as well. There are so many ways in which nitrogen, fecal enterococci, and phosphorus pollution from septic systems can enter our waterways, and that's not necessarily just defined and relegated to the critical area. So by amending in considerations for the floodplain, as well as offering homes with hydric soils that may not be in the critical area, but may be nearer to a non-tidal water body, this will really help in limiting nitrogen and non-point source pollution going into our local waterways, which is important for our communities and our rivers. So I request a favorable report from this committee. Thank you very much.
Okay, good afternoon, Mr. Chair and members of the committee. My name is Eddie Harrison, and I'm the legislative liaison for MALPA, Maryland On-Site Wastewater Professional Association. MAPA appreciates the Maryland Department of Environment's efforts to improve upon the Bay Restoration Fund and the fund's purpose of reducing nutrients to the Chesapeake Bay and trying to get the best value for their money. Sorry. MALPA is in support of SB 117 with amendments, which the amendments have been addressed. The BRF program is a very successful program to remediate failing on-site systems throughout Maryland. MAPA's membership has no consensus for the other positions, the impaired waterways and changing the age of the qualification. We have a diverse group, so we'll get different opinions from everybody. MAPA is in favor of expanding BRF funding to include drain fields. MAPA had concerns about the ranking portion of this bill and performance-based funding levels for each BAT. MD MALPA and other advocates participated in a conference call on Monday to discuss these concerns with this piece of legislation. I thank MDE and all the other participants in the call for all of us to come to a mutual agreement to amend this bill. MALPA looks forward to discussions with MDE and other advocates to address concerns that MDE has and possible support future legislation. I vote for, we go in favor of this bill. Yeah, favor. Thank you.
Thank you, Mr. Chair. And members of the committee, Bill Castelli on behalf of the Maryland Realtors. And the Realtors are in support of the legislation. They're okay with expanding the septic programs. They feel that this program provides some important financial assistance to a lot of folks with failing systems and in helping them purchase high-performing systems. But because it is expanding the program and the use of the program, one of the things they want to make sure is that there is going to be available funding. The way the septic program works right now in terms of the grants, that money is given to the counties. People apply for those grant programs. Sometimes that money runs out for certain counties. So we just want to make sure that the money is available for homeowners that need that money, especially homeowners that are going to be affected by any of the new requirements. And I think some of the amendments address that. The one thing I would say is that the wastewater treatment portion of the Bay Restoration Fund is, right now they've got about 65 of the plants done, of the 67 wastewater treatment plants. So we do think that in the future, this committee and others will be able to look at some of that funding as well and whether it needs to be rebalanced in terms of like some of the septic systems. So with those remarks, we encourage a favorable report.
Thank you all. Are there any questions for this panel? Okay, that concludes the bill hearing on House Bill 131. We will turn to House Bill 262, departmental bill from the Department of Agriculture, Maryland Agricultural Commission, and Young Farmers. We can bring up the department.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. Secretary Addix regrets that he cannot be with us. The Appropriations Committee is also holding their Bay briefing today, so you just get me today. House Bill 262 alters the membership of the Maryland Agricultural Commission, which we also call the Ag Commission, It will eliminate certain seats and add others that will provide a broader representation of the present-day industry. The bill also establishes a committee on young farmers. So currently, it's a 31-member commission that advises the secretary on agricultural issues across the state. We try to have representation that's broad across several parts of the industry, dairy, poultry, forestry, what have you. And so as the agricultural industry has evolved, last year the Ag Commission set up a strategic plan process where they sat down and they reviewed what's working well for the commission and what things they thought they should change for the future progress of the industry in Maryland. And basically, they decided to make the following changes. All of the membership of the Ag Commission unanimously voted to make these changes in membership. And so what it would do is it expands the existing agritourism seat to a value-added agricultural seat. It amends the horse breeding seat to represent the entire equine industry. It clarifies that the horticulture seat will focus on fruit production, and that will serve as a sister seat to the vegetable producer seat. It modifies the nursery seat to nursery, landscape, and greenhouse, as that industry has grown exponentially in recent years. It removes duplicative seats for poultry, dairy, nursery, and related agricultural service seats, and it also removes the longstanding tobacco seat since that industry has diminished in Maryland significantly. And so there have always been a dairy 1 seat, a dairy 2 seat, a poultry 1, a poultry 2 seat. It simply eliminates that second seat, so that creates space on the committee for another industry to take its place. And so the new seats that would be added in place of those that are being removed are a seat for controlled environment agriculture, a seat for urban and small farmers, a seat for historically underserved farmers, a young farmer seat, a veteran farmer seat, and a new and beginning farmer seat. So as the industry grows, that broadens it a little bit more so that we can get some more perspectives on the committee. So let's say you are in an industry that isn't necessarily represented by one of the standing industry seats, you now have the opportunity to serve on this commission. MDA would also like to offer a technical amendment at this time. And so currently the statute for the Maryland Ag Land Preservation Foundation, MALF, requires that one member of the Young Farmers Advisory Board serve on its board of directors. What this bill would do is it would make the Young Farmers Advisory Board defunct. It would create the Young Farmers seat on, the Young Farmers seat on the Ag Commission in addition to a Young Farmers Committee. And so the amendment basically specifies that a representative from the Young Farmers Committee who sits on the Ag Commission would serve on the MALF board. And so that clarifies the MALF board membership piece. And with that, we appreciate the committee's consideration and request a favorable report.
Great, thank you. Any questions on this bill? Madam Vice Chair.
Okay. I wanted to check about Shore Rivers. I don't know if it's the same, has a favorable with amendment about incorporating conservation education.
So
I don't know if you've seen that and clarifying expectations and time commitments.
did they ask for a conservation education seat on the committee, on the commission?
Include language emphasizing the committee's role in pursuing education on conservation practices and water quality as a vital components of farm resource management. This addition will align with the committee's mission with Maryland's goals for sustainable agriculture and environmental stewardship.
Sure, we'd be happy to talk with Shore Rivers more about that. That wasn't something that they'd addressed with us prior to today, but the executive director of the commission is signed up to testify as well. And so again, this was something that the strategic plan that the commission discussed, they decided and voted on these changes, but I do know that they have several standing subcommittees, and I'm sure one of those subcommittees could easily take on as part of their goal and mission the outlined concerns that Shore Rivers has just raised.
Yeah, and there was just, again, some clarifications about expectation and time commitment as it relates to the demand on young farmers. So I don't know if you saw that. Just
No, I
wanted to check in about that. Thanks.
We will look into that, Madam Chair, Vice Chair, thank you.
Any further questions? Delegate Otto.
Thank you, Mr. Chairman. Just to clarify, is this reducing the members of the commission?
No, it simply alters the membership. So like I said, it'll remove some seats,
So
right?
it's still going to be 31, did you say? Or
It should still be 31 members.
my concern is certainly poultry, and that reduction is concern to me, but that doesn't preclude them not being the young farmer representative and things like that, so.
Yes, that's correct. And so there will still be one standing poultry seat. There just won't be two representatives from poultry on the seat. And the other issue, one of the other reasons that the commission decided to do that is it has grown harder to get multiple members from the same industry to participate and to, apply to be on the commission. And so this kind of helps to address some of that. But certainly members of the public who represent the poultry industry already come and participate in those meetings and weigh in. The meetings are open to the public. And again, yes, anyone from the poultry industry or any of the industries could apply under one of those more generic seats and still serve.
And the commission, the existing commission was unanimous in supporting these changes?
Yes.
Thank you.
You're welcome.
Delegate Otto, I thought you were going to ask about adding a foraging member to the commission. Is that not? Any further questions? Okay, thank you, Rachel. We'll now call up Harrison Palmer from the Maryland Agricultural Commission, also favorable.
Good afternoon. My name is Harrison Palmer. I'm the Executive Secretary of the Maryland Agricultural Commission. Thank you, Chair Corman, Vice Chair Boyce, and all the members of the committee for our testimony today. Rachel covered the meat and potatoes of the bill, what we're requesting, and we submitted some written testimony to outline some of the history of the commission, where it came from, where it's going. But the important part of all of this is that this is a grassroots effort that the commission worked on for, I think, 4 or 5 months in an effort to become more effective, more efficient, and offer broader representation. The Ag Commission's played a really integral role in representing that boots on the ground perspective to the executive branch, predating the Department of Agriculture, and then now obviously serving the secretary. But it provides that perspective that really works together to have that collaborative approach and understand what does the industry need, what does the industry want, and how can we be of service to them. The commission has existed for over 60 years, and these grassroots decisions and efforts through the strategic planning process to be more efficient are exactly why we're urging a favorable report, and happy to address some of the questions from Vice Chair Boyce and Delegate Otto. We have 5 standing committees right now: Committee on Watershed Strategies and Committee on Agricultural Education and Literacy, that do both of those things. They work within the watershed strategies, the environment, very closely with our resource conservation team of the department to understand both the educational piece and provide weigh in on the department's initiatives within the environmental collaborative field. And with respect to your question, Delegate, the movement to one poultry seat was really looking at the responsibility of each commission member. You are the representative of that industry, and it's critical that we have the right people that are industry experts and leaders bringing that perspective to the table and advocating for all sides of the industry, whether it's the integrator, the farmer, or whomever is going to be involved in that piece. So with that, happy to answer any questions. Thank you all for your time, and we urge a favorable report.
Thank you very much. Are there any questions? Okay, that concludes the bill hearing on House Bill 262. We'll now turn to House Bill 104, Maryland Farms and Families Fund Purpose and Use Alterations. Ms. Jones, please go ahead when you're ready.
Okay, thank you. Alrighty. So the MDA manages the Maryland Farms and Families Fund. The program's purpose is to double the purchasing power of food insecure residents of Maryland with limited access to fresh fruits and vegetables. So it basically takes a program we call Maryland Market Money, where let's say with your SNAP or WIC benefits, you have $30 allotted for produce purchases. You can take those benefits and you can go to a farmer's market, and through our Maryland Money Market program, that gets doubled. It turns into $60 that you can then spend at a local farmer's market and get fresh produce, as opposed to going to the grocery store and just getting the standard value for it. The issue with the program, what we're asking to do with this bill, is to streamline the process. So the law as written states that the fund has to be awarded to a nonprofit organization. In recent years, throughout the time that the program has existed, we've never had a nonprofit apply for it. And so what's happened is Marbidco has traditionally stood up entities that served as a nonprofit, that applied for the funding, and then awarded that funding to a governmental entity, the Southern Maryland Agricultural Development Commission, SMATIC. So SMATIC has always been the one to issue the Maryland Market Program to various farmers markets throughout the state. And so what we're asking to do is to amend the law so that we can, it gives us the ability to distribute the fund to a nonprofit or a governmental entity. And that way we could continue to work through the existing MOU that we have with the Tri-County Council of Southern Maryland, which is the sort of parent entity of the Southern Maryland Agricultural Development Commission. That way it streamlines the process. Instead of us going through the process every year and issuing a brand new RFP and extending the process for how long it takes us to award the funds to the farmers market, we're making sure that people are able to get these benefits and utilize them in a much more efficient and faster means. And so we ask for a favorable report on this and allow us to have the ability just to streamline this process and make sure that we can operate this program in a much more efficient manner. And with that, we ask for a favorable report.
Vice Chair Boyce.
Thank you, Mr. Chair. Thank you, Rachel. Can you just speak to the current timeline to getting funds versus the anticipated timeline for funds, to get funds and then distribute?
Sure. So my understanding is from the time that the RFP goes out, we know we're going to get the same applicant, but then the process can still take, on average, about 2 months for us to get those funds dispersed and distributed. And so if we could just utilize the existing RFP, we believe we could shorten that process because we know we have one entity that applies every year on behalf of someone else, and then the pass-through of MDA taking the money, giving it to one organization. The other organization has to go through their bureaucracy and then award the funds to SMATIC. It would just be so much quicker. Our end, it takes about 2 months, and then what happens with the other organizations as the money passes through, it just delays the process.
So we're going from 2 months to 1 month, 2 months to
We hope
3
to get
weeks?
it down to 1 month, 3 weeks, something like that. We hope to reduce the time significantly.
Thank you.
You're welcome.
Any additional questions? Okay, thank you. We have another in-person, I think favorable, Paul Ellington. Did we get it right this time?
Yes, sir.
Awesome.
Thank you. Hi, I'm going to keep it brief because you did such a good job. But Worcester County, I'm here on behalf of Worcester County, but also Crisfield and Cambridge. And we couldn't be happier than to know that some of the barriers to access to nutrition are available for just not the farmers markets in the well-to-do neighborhoods, but to those across the state and economically challenged. We have food deserts, and in many ways, this is the only access that our citizens have to fresh fruit, fresh vegetables, and we strongly urge a favorable report. Thank you. Thank you.
Thank you. Any questions?
Oh, Mr. Chair.
Yes.
If I may, I did forget to mention, we'd like to submit another technical amendment on this one. We'd like to submit an amendment that clarifies that the definition of person includes governmental entities. So again, that makes it very clear that we could pass it through directly to the Tri-County Council for SMATIC.
Okay. Thank you very much. That concludes the bill hearing on House Bill 104. We'll roll to House Bill 114, Pesticide and Pest Control, revisions to Pesticide Applicators Law, and repeal of obsolete provisions.
Thank you, Mr. Chair, Madam Vice Chair. So this legislation basically amends the portion of the agriculture article that regards pesticide applicators and who can apply restricted use pesticides. So in 2023, the EPA changed their regulations on the application of restricted use pesticides. And as a result, all state departments of agriculture were required to come up with a certification plan for how we would now certify pesticide applicators to be able to apply these specific type of pesticides. And so MDA came up with its plan, it submitted it, the EPA approved it. in 2024. And so at this time, we are simply trying to conform state statute to the updated EPA regulations. And what that does is the plan that MDA came up with says that non-certified applicators have to complete the training outlined in the rule, the EPA rule. They have to complete worker protection standard handler training or complete a program approved by the state. Those are EPA's guidelines. Our program approved by the state would be as follows. It's three separate points. The first is that commercial applicators of restricted use pesticides, commercial applications of restricted use pesticides must be done by either a certified pest control applicator or a certified public agency applicator. And I know that we did hear in the Senate hearing that Baltimore City had a concern about whether or not their employees would be able to still apply if any governmental entity already has certified public agency applicators. Those folks, they already have that certification. They have to renew it on an annual basis anyway. They would still be allowed to apply under these new guidelines. They would be able to apply those restricted use pesticides. The second is that private applications of restricted use pesticides are done by either a certified private applicator or an individual working under the direct supervision of a certified private applicator who is certified in the specific category of application being utilized. And the third is that a non-certified applicator can only use restricted use pesticides under the direct supervision of a certified private applicator. And that part addresses for folks who may have a family business where, folks utilize pesticides, and let's say a father or a mother owns the license, but a son or a nephew, someone else works for the company business. If they're under the direct supervision, then that additional staff or family member is not required to also be certified as long as the pesticide is applied under the direct supervision of the person who holds the license. So the current law states that restricted use pesticides can only be applied by or under the direct supervision of a certified applicator, and private applicators apply RUPs to their own rented land, to their own or rented land to produce agricultural commodities. This is no longer in compliance with EPA regulations. And so with that, the MDA thanks you for your consideration and requests a favorable report.
Rachel, do you have anyone else testify? Is it just you? There's no Steve? Steve's not here.
Please, just me.
Okay. Delegate Ruth.
Thank you, Madam Chair. Thank you so much. Just a quick question. You're doing this, I understand, because of the new EPA regulations. We don't know from one day to the next what's coming out of Washington, D.C., but would you say these are a good idea even if those regulations from the EPA are no longer in effect?
Yes, these regulations were adopted or promulgated under the Biden administration, and this is what was determined was best for the environment, and just ensuring that people are properly trained before they're applying restricted use pesticides. So these aren't the pesticides that you would just find in the grocery store. These are ones that typically commercial businesses or state governments or government entities are applying. And so we just want to make sure, the federal government wanted to make sure that people who are applying them are properly trained. And so I still believe, MDA still believes it's a good idea.
Thank you.
You're welcome.
A clarifying question, Rachel. Especially whether you mentioned the city and then a private, and so is there a requirement to keep some type of internal log? So if even though I'm a private applicator, I have staff, is there a requirement that says that you train them, or is it just that I'm watching you spray and I'll just tell you where to spray or not to spray? But is there like an internal requirement saying that I have train this employee to do this, or they've been with me in X amount of time to know, quote unquote, better under my supervision how to apply? Are we just taking their word that they've somehow done some in-house training, and or it's just that they're literally standing over them, watching them at the...
So our pesticide regulation section does go out if we get complaints that someone believes pesticides are improperly being sprayed or utilized or applied. And so as a standard, we typically take people's word for it. But if we get a complaint, then our staff does go out and inspect or review, and we also ask for copies. We can request copies of what various applicators have applied, and then we have ways where our team can follow up to see if that was done properly or under direct supervision as it was supposed to be, but we don't have a standard process for training for those who are under supervision. The training and the test, our pesticide regulation section issues tests on a regular basis where people have to come take the test in person while they're being supervised, and they have to pass that test in order to get these certifications. And so
the certification is essentially the standard.
Yeah.
And for everyone.
Yes.
Thank you.
Mm-hmm.
Thank you very much, and thank you for this. I want to get a couple things on the record, especially with regard to neonics. You know, we have very specific Maryland law about, it's not necessarily something that's restricted by the federal government at this time, but it is restricted in Maryland to only be applied by professionals, people who have these kinds of training. And I want to be clear, for the record, that does this in any way impact that? Because you say it's related to the federal standards. Does this remove any of the Maryland standards for neonics?
Delegate Healy, I'd have to look and see whether or not neonics is a restricted use pesticide, because off the top of my head, I'm not certain, so that's something I'll have to get back to you.
It is not, well, it was not by the federal government, but in Maryland, we say that it can't be sold over the counter to the general public. It has to only be sold to people who have the expertise to follow the guidelines that are in place in the federal law, so that it's not overused. And we passed that law in 2016, and and we've upgraded a little bit just to make sure that it's enforced at the grocery store level. You know, that they're not put on the grocery store shelves in Maryland only, because this is a Maryland law. So I want to make sure that this doesn't interfere with the restrictions that we've placed on neonics in Maryland.
This would not supersede any existing laws about other products that are already banned for use or sale in Maryland. If the product is already banned for sale
it's
in
not
Maryland,
banned. It's just
restricted.
It's just restricted only in Maryland, not at the national level. So this is just to get this on the record as we're going forward with this bill. I think it's a good bill. I just want to make sure that it doesn't weaken the protections that we have in Maryland for the pollinators.
Sure. I don't believe it does, but I will double check with our state chemist and with our pesticide regulation section to see whether or not that is on the list of RUPs. And again, it would just mean that someone going through this process would have to be certified. But if Maryland law already says that it's restricted and cannot be sold in stores, then this would specify who could apply it. And it means that it would have to be someone who has one of the particular licenses or certifications mentioned in the bill.
That's great. Thank you so very much. Appreciate it.
Thank you, Delegate. Are there any other questions? Seeing none, that ends the hearing on HB 114. Back to the Ag Show. HB 140, Agriculture, Soil Conservation, and Water Quality Plan, Uses of Information. You may start when you're ready.
Okay. Thank you, Madam Chair. HB 140 grants the MDA the same authority that the MDE currently has to request a soil conservation water quality plan from a soil conservation district. So many of you know soil conservation districts, or SCDs, are a subsidiary of MDA. They're considered MDA employees, but it is a quasi-independent agency. So therefore, everything that they do does not necessarily get transferred or is not synced with the data that we maintain on file at MDA. And so what this bill would do is MDA's authority would be limited strictly to nutrient management compliance measures contained within a soil and water quality plan. So for example, if the nutrient management team were investigating for compliance purposes only, whether or not livestock had access to streams or bodies of water, they would be able to request from a soil conservation district a copy of a soil and water quality plan for that particular property, just to see if there was any evidence that there was knowledge that this is something that would have been required on that property in order for them to be in compliance with their nutrient management plan. And so this would not make every single soil and water quality plan available to the MDA. This would only be, again, the same as it is for MDE, for enforcement purposes and upon request, only if there's some sort of current investigation about whether or not there's a compliance issue for a specific property. And so it's simply a matter of trying to enhance our compliance. And again, there would be parity with what the MDE already has the authority to, upon request, have a copy of a soil and water quality plan. And with that, we'd ask for a favorable report.
Before I call up the next favorable testimony, I wanted to just clarify a couple of things. Some of the projects that the soil conservation districts perform are voluntary. And so I guess there's a question or a concern that those folks who are doing these projects on a voluntary basis would be then dinged somehow, for performing services that are otherwise needed and used for those districts. Can you, I mean, you did specifically say that this would be like a PIA for soil conservation district information. I guess I'm wondering about a process prior that is, it's an ask and then the request is given, but it would be based on whether or not someone is potentially negligently contributing or accidentally contributing to, I don't know, I'm lost for words, but go ahead.
No, I understand what you're asking. Madam Chair, if I may, our Assistant Secretary for Resource Conservation, Hans Schmidt, is here.
Yes,
Would he
please.
be able to answer that? That's a technical question I'd like to defer to him on.
Please make sure you state your name for the record, please.
Good afternoon. For the record, I'm Hans Schmidt. I'm the Assistant Secretary for Resource Conservation at the Maryland Department of Agriculture. So we have a process in place when nutrient management is going out and doing investigations. We reach out, we do our regular reviews, but when we meet with farmers, particularly in a situation, as Rachel just mentioned, for setback and where livestock may have access to water bodies, we meet with the farmers, we try to address the issue through conversations, and we encourage those farmers to work with their local soil conservation districts to address the issue. We have a process where we'll come back in 30 or 60 or 90 days to just do some follow-up, understand from the farmer where they're at in their process. Where this bill gives us the ability is for what I would say the bad actors, the ones where we're not getting any progress in trying to find some solutions. Nutrient management regulations require that animals need to be excluded from the streams. We have cost share assistance to help farmers pay for fencing, pay for waters and so forth, so that they don't need to be in the streams. But when we run into these situations where we're not getting any progress, the purpose of this bill is so that we can request, just as MDE does, for nutrient management compliance issues, is to have a view of that conservation plan so that we can see what progress is making, how that what that farmer's working on, what the district is working on, so that we can work through our compliance measures, in a faster manner. So this, again, as Rachel mentioned, this is the same progress or the same access that MDE is. It's only for nutrient management compliance and no other. The conservation plans are a plan, it's between the district and the farmer. And it's a confidential plan that that gives the farmers the ability to use that plan for conservation measures on their farms. But when we get into situations where we're just not getting any cooperation from the farmer, again, it helps us in our means It still gives, the voluntary nature between the farmer and the district, but it also allows MDA using their internal resources to use if we have to go down an enforcement route.
And just again, so that I'm clear before I move on to the other delegates who have questions, MDE can just request the information and get it. And what you're saying is you can't. So I guess the question I have, if there are concerns, is what is the difference between MDE being able to ask the same individuals for the information versus you?
MDA regulates nutrient management.
Right.
MDE does not. So this is where we're just using this for for nutrient management.
But I understand that, but MDE right now could say, Soil Conservation District 17, I need X, Y, and Z for this space and place, and then they give it over, is what I'm hearing you say.
Yes.
And then last question, you mentioned soil conservation districts are a subsidiary of ag? I didn't know.
They're a political subdivision of the state, so the soil conservation districts have both MDA staff, NRCS from USDA, federal staff, as well as some districts have some of their own local district staff, county staff.
Okay, Delegate Jacobs.
Thank you, Madam Chair. And I guess, Hans, you probably be the best one to answer this. You're the soil conservation guy. In the testimony, there's a lot of favorable testimony, but the testimony from soil conservation is informational only. Now, I spoke with, I guess it was Soil Conservation Day, Monday and Tuesday, they were over, and I spoke with several of them, and they did not seem to be supportive of the legislation. In fact, they said they didn't know anything about it until they got there Monday, which Monday would have been the deadline to sign up for today, had they known. So that was a problem right there. But one of the things, and I know we've historically done this, is protect the information. There have been years that, they've gone after trying to publicize nutrient management plans and things of that nature. And we've always been very careful to make certain that didn't happen. And what they indicated to me was that this trust factor is such an important part between farmers and these agencies that they were concerned of what kind of negative impact this may have. And I think that, from my understanding, there was only 1 or 2 cases that this is really involved in. So, I always think about the information that Speaker Bush said to me when we first got elected, is the juice worth the squeeze, when you get yourself in a tight situation. So I'm asking in this bill, given their concerns with this information and this credibility between farmers and these agencies and sharing that information, is for 1 or 2 cases, is the juice worth the squeeze to do this? With an agency that only submitted information that directly deals with them. So I would think if they were in favor of this, would have been favorable testimony.
I understand the concerns. I came from MASCD. I'm a farmer myself, and I understand where they're coming from. I will say this too, the cooperation and the partnership between the soil conservation districts and the farmers have been what I would tout as how come the reason why Maryland agriculture has done so well with meeting our Chesapeake Bay goals. There's not a better partnership in the country than what we have in Maryland between our districts and our farming community. We have done so much. We've gotten a lot of the low-hanging fruit, and now we're getting really deeper into the weeds as far as trying to find avenues to try to be able to address some of these other concerns. I met with MASCD on Monday and explained that yes, we have 2 major cases going on. One is 4 years old and one's 7 years old right now. Those 2 cases are right now in the enforcement stage. But we do have, a couple other cases going on that we haven't gotten that far. And primarily it's in where we have beef cattle and equine is where. The problem we run into from farmers, if they see other farmers doing this, then the question's going to come up, well, if that farmer can do it, why can't I? And so we need to be able to address these different situations. And I think, again, it still allows the districts to have that voluntary approach with the farmers to make sure that they're addressing, conservation on the ground. But it formalizes our ability to be able to request a plan on these case by cases where if we have an issue, the farmer's not willing to cooperate with us, we can take a look at the plan, see what progress the district has made with the farmer or the farmer's lack thereof, and then be able to build a case against the farmer. So we're not going 4 years, 7 years out. We have the ability. Every farmer, as I said, I'm a farmer myself, and if I've got to follow the rules, every farmer should be the ones following the rules. And so, yeah, I understand where you're coming from, but again, we're just trying to build a case so that we can address these certain situations.
And if I may, Delegate Jacobs, how do you want to address, you did also meet with district managers prior to Monday. So this wasn't the first time that members of MSAD had heard about this bill.
When the bill first dropped, we did have a number of managers had reached out, and we have been meeting with managers to make sure that they understand. I mean, managers really kind of, speak for a lot of times for the boards or for the super, because they are really deep into the weeds. So we've had multiple conversations with them. It wasn't until, Monday when I, as an agency, had a formal conversation with the whole association.
Yeah, well, they indicated they did not receive any correspondence on this, and I'm just telling you, the ones in my district are very concerned with the issues that I raised to you. So just hope that you consider that. Isn't that so?
Yeah, I can assure you we support the voluntary approach. It's important. It's how we get to where, it's how Maryland Agriculture has tried to meet our goals. But again, trying to set up a means that we can go after those who are non-compliant. And yes, it's a very small number, but farmers are looking at what other farmers are doing. And so, we're trying to build our case.
And additionally, you mentioned that there was concern that this would lead to what previous efforts have been made to make people's nutrient management plans public. This would still not do that. It would not make people's nutrient management plans available to the public. It would just mean that soil and water quality plan is available for the nutrient management team within MDA to review as they're trying to ascertain whether or not they are compliant with their nutrient management plan, but it doesn't make that information public outside of MDA.
Delegate Otto.
Thank you, Mr. Chair. I think my friend here covered most of the things, and I think the last answer, the integrity of the confidentiality of these nutrient management plans is important too. Mm-hmm. I mean, it has consequences to the whole business plan of an operation and things. So what is this bill asking for? To have access to the soil and water conservation plans, or is it nutrient management plans? I mean, you have the nutrient management plans.
Yeah, this is for the soil and water conservation plan. The nutrient management plan, we have access when we do our reviews and so forth. We're only talking about the conservation plan, and those are the conservation plans that are housed with the districts.
So cannot the department ask the person that's in question or being investigated for the plan, or have permission to it?
We find that those that we've been working with and who are non-compliant are non-compliant in many other ways. In working with them, sometimes they, pushback for even coming to the farms. So to have them be able to provide us that plan is probably nil.
So who's going to have access with this legislation to these plans from the
nutrient management
district?
The nutrient management program within the district, or excuse me, within the department.
And again, it just gives us parity. MDE can already request the same plan from a soil conservation district. It's just allowing MDA to do what MDE can already do. And we do believe that we already have more of a trust. And for us to even get to the point where we would need to request that plan means there's a serious compliance issue already. So we just wouldn't do it automatically or for the majority of Maryland farmers.
And I would just add too that those who are writing the plans are typically MDA employees and MDA staff. So we're writing the plans and yeah.
So, and you talked about the talking to the district managers and things like that. Are they not the MDA personnel?
There's only maybe a half a dozen MDA district managers in the state. All the rest are district staff.
They're by the local district.
By the local counties.
That raise the money to fund their positions.
Yes. And typically they'll get funds through.
And they were just told about this coming about, not having input into what it entailed or.
Yeah, they were aware of it when the bill was dropped.
All right, thank you.
Vice Chair Boyce.
I'm not going to ask no more questions after this, I promise. So if there's a compliance issue, and it is a compliance issue that has a shared component with MDE, how currently do you manage that to, I guess, combine resources to, I guess, go after this non-compliant person? Because I guess what I'm trying to figure out is that you said you write the plans, but then you don't have access to the plans, which I find weird. But you know, sure. I'm not in your business. But that's fine. And I understand you are asking for access in the same way that MDE has access, and you only need it when you're trying to go for compliance. But I guess the issue for me is that if MDE has access, direct access to these plans, and you don't, but you both tend to have the same bad actors, how do you then attack those issues together?
So let me hit one first.
Sorry.
So no, it's a little confusing because
and I'm slow.
The state, we have an MOU with each of the districts. We provide each of the district different resources.
Right.
Not every district has the same number of planners or technicians, so it all depends on what the needs are. The same on the federal side. So we assign those staff to the districts, and then those staff work for the needs of those districts, trying to meet the goals of the district and meet our goals within the MOU. We have a separate MOU with MDE for enforcement purposes, not so much on the nutrient management side, but for other compliance issues that we address. And it's a way of both agencies being able to work on whatever the violation or compliance issue may be. Okay. It's not necessarily a nutrient management. It may be something completely different.
Okay. And so, again, to meet your goal, other than you want the same access for when you want to go out for a bad actor, you can otherwise not do this or get the information in a timely manner without this legislation. Correct. Is what you're saying. Okay, correct. Thank you.
And Madam Chair, MDE would not necessarily, while they're great partners to coordinate with, they aren't required to provide us with something that they have access to. And so it's not like we could easily just ask MDE, well, give us a copy since you've already requested one, you have the authority already. It's not that streamlined, and so they're not required to, just like we're not required to provide them with a copy of someone's nutrient management plan. We don't do that. And if they do want it, we do make them go through the PIA process in an effort to keep people's private property nutrient management plans private. And so while we're each doing our job to enforce and regulate accordingly, we do not necessarily share information about things like that.
Okay, any further questions? Delegate Dewey.
The question that I'm not sure I really understand what the purpose is of having all of this being so secretive and private. And I mean, if somebody has a nutrient management plan and it works, shouldn't that like be shared so that everybody could use it the same way?
No. Nutrient management plans are owner of the farmer, and those plans are written by certified nutrient management plan writers. And it's like a business plan. It may lay out exactly to the farmer how he's, when to apply those nutrients, how to apply those nutrients, and so forth. And every farmer is going to have a different nutrient management plan, but it's still going to fall under the requirements or the guidelines that's allowed within the nutrient management regulations and law. So it's a business plan, and every farmer is required to have that nutrient management plan. They use it as a business. If that were to go out to other farmers, then that's almost like giving your business plan to another farmer to use to their advantage. And to just add to that, there's a lot of land in Maryland that's rented ground. And when farmers are competing for that rented ground, if they have access to see what's working and what's not, it becomes problematic for those farmers.
Well, yeah, but we're making policy for everybody, for the state, for the land itself, that it gets treated the right way by everybody, right?
So again, the soil and water conservation plan is designed by the soil conservation districts to address what are the best conservation practices to implement on those farms. So it has nothing to do with nutrient management. It has, per se, other than it has specific setback guidelines and a couple other things. Nutrient management plans are really solely, besides, for certain purposes, tells how much nutrients, limits the nutrients of what can be applied on the farm. The soil and water conservation plan provides the best avenue for the farmers to what conservation practices need to be implemented.
Okay.
Again,
Thank you. I see the value of this legislation, that you really need to have the information. Thank you very much.
Okay, any further questions? Okay, thank you both. We will now call up another in-person, maybe favorable testimony. Paul Ellington, State and Local Advisors.
Thank you, Paul Ellington, representing Worcester County. I don't want to delay your day. We support that. We echo the concerns about the privacy of the plan. I think they've been adequately addressed, and we just ask a favorable report. Thank you.
Thank you. Any questions? Okay, that concludes the bill hearing on House Bill 140. We'll turn to House Bill 244, Plant Disease Control, Nurseries, Inspection Certification, and Licensing Fees. Ms. Jones, please go ahead.
Thank you, Mr. Chair, Madam Vice Chair. So we talked earlier when we talked about the Ag Commission bill about the expansion of the nursery landscaping industry in the state of Maryland. And so currently, this legislation would grant MDA the authority to alter the fees that we charge for inspecting nursery stock. As the industry has grown and we've seen a growth in more nurseries across the state, that means that our team is operating with the same number of people, same number of inspectors off of the same fees. It's an entirely specially funded program, which means we have no general funds to increase staff, to increase inspections for the growing number of nursery and landscaping operations across the state. And so Maryland law requires anyone who advertises, sells, installs, or produces nursery stock to be licensed with MDA. I want to point out, I know that, everyone knows what the state of the budget is, and I know that there's angst about increasing fees. These fees have not been increased since 2004. That means our team that is operating off of special funds, their salaries, their benefits, their equipment, their vehicles, all of their supplies are all based on the fees set 20 years ago that have not increased with inflation. That means There's high turnover in that department because the salaries are not competitive. And again, it requires that people travel all across the state and inspect and make sure that these nurseries are licensed and compliant with the laws that we've got about native plants and invasive plants and what can and cannot be sold. And so what we're requesting to do is, in order to have a more efficient operating budget, we're asking for the ability to increase the fees as follows. So the inspection fees are based on the number of acres that a nursery lot has. And so for an acre or less, the fee is currently $10. We'd like to increase that by $10 to $20. For a lot that's 1 to 5 acres, we're asking for another $10 increase from $20 to $30. It's an annual fee. For a 5 to 10 acre lot, it's currently $30. We're asking to increase that to $40. And for more than 10 acres, the current fee is $3 per acre. We're asking to increase that by $2 and make it $5 for each acre with a maximum of $1,500. The previous maximum was set at $1,000. And we would ask to increase the annual nursery certification fee to $150, up from $100. The broker or dealer license fee, we would also like to increase from $100 to $150. And so we understand that no one's keen on raising fees, but in order for us to continue to do our jobs and to regulate the industry as we are required to do by law, we would really love to be able to do that more efficiently and to be able to do that in keeping with inflation. And with that, we'd ask for a favorable report.
Great. Any questions on this bill? Delegate Healy.
Thank you very much, Mr. Chair. Just quickly, for many years, it was one of my jobs when I was on Ways and Means to kind of bird dog all these fees and make sure that they were being set to cover the cost of the services that they were collected for. And we used to put like boilerplate language in saying some words to that effect. Some did not want it. Some really pushed back hard. And so that's why I'm asking if your department has a reason why you would not want to just set it so that it gets reviewed in the budget process so that it's actually covering the costs of the services you're providing through that fee.
Certainly. Ideally, we would love to be able to do that. Ideally, we'd love language that would give the secretary the authority to set the rate, and we would ask to do that through regulations and come before the AELR committee of the General Assembly, every few years if we could do that. But because the fees are set in statute, we do have to.
But this is an opportunity since we're opening up the statute.
Yes.
For legislation. I just wanted to ask the question because it might save a future person in your position from having to come in and say we don't have enough money to provide the services that people are paying for.
Certainly. I will say that our team in the plant protection and weed management section that asked for this particular increase, they looked at the next 5 years and their projections for the current nurseries that we have and anticipated a handful of new ones that they thought we might get, and they set these increases based on what they thought they might need to adequately cover operating costs for the next 5 years.
Thank you so much.
You're welcome.
Any additional questions? All right, Delegate Jones, you made it through your gauntlet here. Thanks for being with us. That concludes the bill hearing on HB 244. We'll turn to HB 277, Delegate Ruth, Environment Water Bottle Filling Stations Requirement.
I heard that. Good afternoon, Mr. Chair, Madam Vice Chair, and my fellow members of the Environment and Transportation Committee, the best committee in the House in the entire legislature. And I'm not pandering. So I'm here presenting House Bill 277. You saw a version of this last year which passed the House, and it actually made it to the Senate floor where it died at midnight on sine die. So I am bringing it back this year. It is not in the same posture, though. There are some changes which I'll get into in a minute. But in a nutshell, this is a simple bill to address solid waste. And we know single-use plastics are clogging up our roadways and our waterways and the Chesapeake Bay, and they've become excuse me, a huge problem. Everywhere you go, it's impossible to not see single-use plastics. I think that was a double negative. Anyway, you know, and we are working on recycling, but recycling rates are still low. But this committee has, you know, worked on those types of things. But we're still having a plastic waste problem. Plastic, this is not bad about plastic because plastic has revolutionized some industries, such as it's used in medical devices where it's really invaluable. But we too often sacrifice our health and the environment for convenience. And this is one of those cases where it's convenient to buy a plastic water bottle. So this bill does not ban plastic water bottles. It does nothing to take away anybody's choices. All it does is it says new construction, which is already required under the International Plumbing Code to have a water fountain, must also install for each water fountain a water bottle filling station. And you can buy combination units. They're a little bit more expensive, but you can buy a unit that's a water fountain and a filling station. I'm sure you've seen those. So this should be a really low barrier bill. My understanding is many buildings are doing it anyway. Many builders and architects are doing it anyway. And you'll actually hear the architects, I think they're here, they signed up in support of this bill. Excuse me. New this year, at the request of the American Heart Association, we added renovations. I tried to keep it, again, that same low barrier. So if a renovation is already required, is going to be replacing a water fountain, then they're required to replace it with one that has a filling station in it. Or if, say, it's an addition, a new wing or something, that might now be required to have a water fountain under the International Plumbing Code, that it just says install one of these combination units or separate units as well. So it's a very simple bill that provides consumers with choices, where it makes it much easier, and these non-plastic water bottles, refillable water bottles are becoming more and more common. Everybody knows I carry mine around everywhere. I've left it in a few restaurants, but always got it back. But they're becoming more common, and people love that they can fill up their water bottles. And so this is a bill that provides choices. And so before I go on too long and use up my goodwill, I'm just going to mention a couple of things. I wanted to first of all address the fiscal note, which is generally pretty positive, but there was a comment from University of Maryland College Park and about the fact that it would be a significant financial burden to replace all their water fountains. The problem is this bill does not require them to replace all their water fountains. So if they're doing a renovation anyway, then they would have to replace it, but nothing require, and University of Maryland is huge. I'm sure they have a lot of water fountains. So they only have to do it if they're doing a renovation. Nothing requires them to go in and replace any water fountain. So I do have a call into the government affairs team at College Park, and he's gonna get back to me about that. So the other thing I wanted to address is the NAIOP testimony, which is the only unfavorable testimony. And I honestly, I'm not sure they completely understood the bill, and it's a shame. I don't think they're signed up to testify orally. So it's too bad that the committee will not be able to ask them about their testimony, because I think it would have been good to have some questions about that. But just a couple highlights about their comments. They say whether the fixture is a kitchen sink, water fountain, refrigerator-based water dispenser, or water bottling filling station depends on a number of factors. In event, all these fixtures can be used to refill water bottles. Well, kitchen sinks are not, I mean, this bill does not have kitchen sinks in it, so nothing requires a kitchen sink to be replaced with a filling station. While water fountains potentially can be used to fill a bottle, it's hard to do when the water comes up this high and you're going like this trying to get it in. They also say the bottle fillings, oh yeah, they say something about in here about tenant spaces. Limited foot traffic or tenant spaces that have ensuite kitchens may be of little use. And I did want to clarify, the International Plumbing Code does not require any kind of water fountain in an apartment or a condo or a single family home. And I have in the appendix on my written testimony a list of the places water fountains are required under the International Plumbing Code. And it does say residential, dormitories, fraternities, and sororities are required to have one water fountain per 100 people. Congregate living facilities, which would be like a nursing home, I guess, with 16 or fewer persons. And they are not required for hotels, motels, apartments, or single-family homes. So nothing in this bill requires any kind of fixture to be installed in an apartment or a single-family home. And so with that, I'm happy to answer questions, and I ask for a favorable report on HB 277.
Great. Questions about a policy we passed last year. Delegate Foley?
Yes, thank you, Mr. Chair. This is a question that arises from the fiscal note. And at the end of the fiscal note, there's an additional comment that says that MD Labor advises that it's unclear if the bill allows installation of a water dispenser that is not connected to a potable distribution system or sanitary drainage system as a reasonable substitute for a water bottle filling system. Would you be willing, I mean, I assume that's like a water cooler type thing. What are your feelings or opinions on that?
Thank you for the question, Delegate. And that was not the intent of this bill. The intent of this bill was to install permanent fixtures because, yes, I believe that's temporary water coolers like we have right here in this building. And a temporary water cooler can be easily removed, so there's no guarantee it would stay there permanently. They have to buy water bottles for it. So that was not the intent of this bill, but if this committee would want to exempt those and change some of them to coolers like we have, I would be okay with that. I would have to talk to my Senate cross-file sponsor and the other advocates. Did that answer your question?
Yes, it did. Thank you. And I think the fiscal note also makes note of that there's a capacity limit on that. In other words, fewer drinking fountains, or it says they're permitted, IPC allows them to be substituted for up to 50% of the required number of drinking fountains. So I just point that out, that, and I didn't know how you felt about it, but I also want to add, thank you very much for bringing this bill. I really like this bill. Thank you.
Thank you so much, and may I address the delegate's question? Thank you, Mr. Chair. I will note that the current version of the International Plumbing Code we're using is the 2018 version. I have not looked at there's a 2024 version that we've not adopted yet, and so I don't know if that same requirement is in the 2024 version, but I'm certainly open to the committee's thoughts on that.
Great. Let me just explain something about the cameras and the microphones that I think is causing some confusion. Occasionally, the camera stays on me when it should be focused on all of you. So while I'm furiously up here typing text messages begging you not to ask questions, it's watching me do that while you're asking your question. So they can force the camera over to you, but sometimes it resets the microphones. So that's why your microphone might go off briefly while you're asking a question. And it also, I believe, turns off the people who have requested to ask a question, which is quite confusing. So they're doing that to make the cameras work. It's a software glitch. It's being worked on. But that's what's going on with the microphones and the camera sometimes. And with that, Delegate Lehman, did you have a question? Okay. Anybody else have a question? Great. Thank you, Delegate Ruth. I believe there's a group of favorable witnesses. Laura Hale, American Heart Association, Chris Parts, AIA Maryland, Chaz Miller, Maryland Recycling Network.
Thank you. Good afternoon, Mr. Chair and honorable members of the committee. My name is Laura Hale. I'm the Director of Government Relations with the American Heart Association, in strong support of this legislation. So instead of in the environmental space, we sit in the health space. And as you all well know, water is very, very good for you, and encouraging everyone, especially our children, to continue to drink water is very important. And we find that water bottle refilling stations really help with that. And we also know that more than half of our children in the United States do not drink enough water. And so by being able to encourage this, as well as having filtered water, many of these spaces actually filter out lead in addition to just being, so it's actually better than a water fountain to get a water bottle refilling station when we think about our kids and especially our adults. And so we were very excited as well to look at, especially as we look at some of our older buildings when they're touching the plumbing. It's important, especially with concerns about lead and just with access, that we continue to look to install these water bottle refilling stations. And so we thank you all and urge a favorable report. Thanks.
Good afternoon, Chair Corman and members of the committee. I'm Chris Parts with AIA Maryland, representing over 2,000 architects in the state here in support of House Bill 277. It's simply sensible legislation that accelerates the slow change of one issue in the plumbing code from being allowed to being required. Just wanted to share one anecdote. About a year ago, I was at BWI Airport traveling to Iowa. I don't know if you've ever tried to fill a water bottle there, but it's very difficult. I went to 5 different locations, finally found one water bottle filling station that had a line of 4 people. The only drinking fountain in the entire airport that I saw that had a line there for folks waiting to fill it. And that one, unfortunately, was not an accessible height, so it was not available for everyone. The new plumbing code does require those to be at accessible height, so if it's installed, it would be required to be at an accessible height, so it would be available to all. And I think that what happens in locations like this is that it pushes people to buy that $5 bottle of water of a single-use plastic. And I know for my family of 6, $30 for a glass of water is kind of expensive. So I think that it's something that, you know, having those stations there would be a practical solution to addressing that. Asking you for a simple yes to this bill that you said yes to last year. Owners, I've never had an owner object to installing those when we've specified those on projects. It reduces plastic waste and it makes clean water readily available for all. Thank you.
I'm Chaz Miller. I chair the Maryland Recycling Network's Legislative Task Force. Our members are public sector recycling managers, private sector recyclers, and advocates. We manage recycling and waste reduction programs throughout our state. We strongly support this bill. It's simply a proven way of saving money, reducing bottles, leading to refill. This is just smart waste management at its best. You don't need the bottles, just bring your own refillable container. I have to admit my own experience at BWI with the refillable water has been very good, and I've used this throughout the country and when I travel. The only thing I have to do is remember to finish the water in the bottle before I go through security. And I do that, and then I just refill it when I'm in the airport. And so we thank you. This is exactly the kind of reuse legislation that we need to see in Maryland. So thank you, Delegate Ruth. We strongly support passage of this bill.
Any questions? Okay, thank you. That concludes the bill here on House Bill 277. We'll move on to our colleague, Delegate Naraki, House Bill 24, Bay Restoration Fund, authorized uses, connection to existing municipal wastewater facility.
Mr. Chair, can my panel come up? Can my panel come up, Mr. Chair?
Yeah, of course.
Thank you.
Is that a co-sponsor next to you?
Yes, sir, Mr. Chair.
Okay, so birthday cards, holiday cards, and testifying, all done. We can't just see one of you? We need 2 sponsors?
We're partners in crime fighting.
Yeah, okay. Delegate Naraki, go ahead.
Thank you, Mr. Chair. Mr. Chair, Madam Vice Chair, honorable colleagues, Delegate Stewart, I'm here today in front of you asking for a favorable report on House Bill 24, the Bay Restoration Fund authorized uses connection to existing municipal wastewater facilities. This bill aims to address 2 critical issues, the Chesapeake Bay's health and our residents' well-being. HB 24 would allow qualifying homes with septic systems to access limited Chesapeake Bay restoration funds to connect to existing municipal sanitary sewer systems. As we know, the health of the Bay is vital both to our environment and our economy. Ensuring that safe, Properly managed sewage connections are more accessible to replace failing septic systems where appropriate is a necessary step in protecting this essential resource. Currently, it can be very difficult, and I want to be clear, it's not impossible, but it can be very difficult to access Chesapeake Bay restoration funds when a home is not located in the critical Bay area. We now have had 2 instances in our district, Delegate Shalega and I, where neighborhoods have had difficulty accessing the Baltimore area sanitary sewer system because of costs. This bill would seek to allow broader access for these kinds of communities. In many cases, when septic systems fail, the consequences go beyond just environmental degradation. These failures can result in serious health risks for residents. However, the cost of connecting to sewage lines remains out of reach for many, particularly for lower income homeowners. This bill would help alleviate that financial burden and prevent the greater costs, both financial and public health related, that arise when a septic system continues to fail for long periods of time. We have deliberately kept the bill narrow in scope, focusing on certain income levels to ensure that funds are used efficiently and for those who need them most. However, we must recognize the interconnectedness of communities. A single septic system failure does not only affect one household, but it can have far-reaching consequences for the surrounding area, including for residents who may not have the means to address any issues that arise. That is why we believe that we must offer some flexibility in income levels, ensuring that those who live near existing municipal sewage systems can connect. One unique element of the areas that we both represent is that you often can have a very broad difference in income levels in homes that are literally right across the street from each other. We believe that if the income threshold is set too low to qualify for these funds, we may have a piecemeal approach created where some are accessing the sanitary sewer system, but not all are ultimately able to link up because of cost to have this beneficial aspect for the Chesapeake Bay's health. We also are aware of the fiscal constraints that we are all working within. To address this, the bill prioritizes connections in areas where there are already existing sewage lines. While we certainly would like to see as many homes as possible be able to connect to sanitary sewer systems, we also believe that prioritizing neighborhoods with existing sewer infrastructure nearby allows us to target the lowest hanging fruit more efficiently and effectively. I want to draw attention to a particular aspect of the bill that I know some have had concerns about, and I want to talk about why it was inside the bill. So there's a provision inside of the bill that we introduced that was to address a specific concern in our district. There is a failing wastewater treatment facility near the Gunpowder Falls State Park called the Richland Manor Wastewater Treatment Plant that has been scheduled for transition to a pumping station for many years, but this is yet to occur. As such, we included language in this bill allowing residents to connect to existing facilities regardless of their current performance, such as the Richland Manor Treatment Facility, to create discussion about this long failing system. We have spoken with the Maryland Department of Environment regarding this facility and are fully prepared to adjust this provision based upon our very productive discussions with MDE regarding the transition of this facility. In conclusion, this bill is balanced. It's a thoughtful approach that will improve public health, protect the Chesapeake Bay, and provide critical support to residents seeking to connect to sanitary sewer systems. We urge you to give HB 24 a favorable report as we create lasting positive impacts for our communities and the Bay. Thank you, Mr. Chair.
Oh, excuse me. Good afternoon, everyone. My name is Patricia Payne. I grew up on Benji's. I grew up near the Gladway, the homes that we're talking about. My grandfather purchased that property back in 1930s. At that time, he just had a house. It did not have proper running water. It did not have proper sewage. In 1970, we were promised to be able to connect to the sewage. We did get the water. We did not get the sewage. 50 years later, I was young when it happened. I will be 68 on Monday. It still has not been properly fixed. It's important to me that you do support this bill. We've been promised proper sewage from when I was a little girl. And if you can see, I'm not a little girl any longer. I grew up in the area. My grandfather worked for the chassis system. My father worked for Bethlehem Steel. My mom went and worked for Middle River Depot in the same area. And there are countless other stories I could tell you about for the people who live there. They did give us that before we got the water, we got a spigot. We had to go up to the spigot, fill up plastic containers to do our laundry, to wash, to do our dishes, whatever, cook with, whatever we had. We have been overlooked forever. 50 years later from the 70s, we still haven't gotten proper sewage. I'm asking you to support that bill. My grandfather worked hard, and he owned that property, which was rare during the 1930s for African-American black men to own anything. So I'm asking for that support. We've been overlooked all these years, and I'm just asking that we get a favorable report.
Thank you very much. Happy early birthday. First question is Delegate Foley.
Thank you, Mr. Chair, and I applaud the sponsors for the sentiment of this bill, but I have a very specific question. This, as I understand it, is supposed to help residents in low-income areas to be able to access funds for sewer, converting septic system to sewer. And the only income threshold I see in here is $300,000. Is that the threshold for low income? That seems pretty high to me, is my point.
Sure. No, that's a fair question, Delegate. Now, so our district, which I think is probably not unique to many areas that are around the water, you will literally see areas where you can have a $1 million home directly across the street from a trailer park, literally. And so what we were trying to get at there, and maybe 300 is not the number, but the idea was that we didn't want to have this piecemeal approach where you might have certain people in a street tying into the sewer system and not having everyone. So we're trying to encourage everyone to tie in. We would like to see not just one house. You can sort of see this sometimes in certain areas where you get one or two. Obviously, we all know the benefits of kind of getting everybody to tie in. Right. So maybe it's not 300, maybe it's 150, maybe it's 200,000. But the idea that I had there was to not make it so limiting that we would only get very low income homes, which of course we want to get to tie in, but not to get some others to tie in as well in these kinds of communities.
Okay, thank you for that clarification.
Delegate Ruth.
Thank you, Mr. Chair. And I hope you'll forgive me. I'm going to ask a Baltimore County specific question. In Baltimore County, I'm sure you know, properties outside the urban-rural demarcation line have to be on septic. They can't be connected to sewer systems. So this would not change that. Is that correct?
Delegate, that's actually not true. There are properties like in areas like Bowley's Quarters and things like that that we represent that are actually outside of the URDL, but that are on the sanitary sewer system because they're in the critical Bay area.
That's okay. That's good to know. I actually had attended years ago. The reason I thought of this is you were talking about people living across the street, and I had attended an administrative hearing quite a few years ago from somebody who was trying to get permission to hook up to the sewer, and they're outside the URDL, but like right at the borderline. So I know there's a process for that, but you're not talking about those types of situations.
No, and Doug, you're absolutely right. There is a process to extend water service. I think in good judgment, we've decided that it's appropriate to extend the sanitary sewer system in some of these areas that are closest to the water. Ms. Payne, for instance, does not live right on the water, her community, but it's close. I mean, we're talking about within a half a mile or so of the Middle River. And so obviously that wouldn't apply because we're not in the critical area there, but many of these communities, we've decided that in good judgment to extend the sewer system in those areas.
Thank you.
Delegate Healy.
Thank you very much. And I want to thank you for your thinking about this. I also have a couple specific questions. I mean, I'm looking at the testimony from the department, and I mean, there are policy, this isn't just about, money. This is also about policy, about allowing certain things that were not allowed in the original law. So if it were just about the money, and that's my real question is, if it was just about money for people who would otherwise qualify on the policy aspects, but they don't have the money to make the transition because the general policy has been, especially in the critical areas, to get people to stop using septic, to be on city water or any kind of water that is really treated. We have that's what the Bay Restoration Fund was started for, was to make sure that all our treatment plants are up to standards. The question is, I noticed in the fiscal note, I didn't see it in the bill, but I looked, that one of the things you propose is a loan program rather than a grant program. And I thought, thinking more creatively, the possibility of setting up some kind of a revolving fund to allow people to borrow and pay back, and then somebody else can borrow from the same fund, and it's not a growing thing. And it would be more limited, and it would be limited by the policies that are set forth in the current law. Is that something that appeals to you?
Delegate, absolutely. I think that does push, but I want to push the ball forward in a positive way here with respect to getting people off of sewer systems, or I'm sorry, off of septic systems as much as we can in some of these areas. I think that makes sense. The reason that we had the loan language in there is I am sensitive to what my colleague Delegate Foley, our colleague, talked about there about the income thresholds, right? So I was, trying to be as broad as possible to get as many people to tie into sanitary sewer systems. But I think the grant idea and those things make a lot of sense as well.
Thank you.
Vice Chair Boyce.
Thank you, Mr. Chair. Thank you, Delegate Naraki, Delegate Shalega. Mrs. Payne, can I ask you a question?
Sure.
So I just want to make sure I'm clear. You in your home have been on septic since the 70s, or you?
Before then, we grew up with outdoor plumbing. We had outdoor outhouses.
So you've had septic for how long now?
When we built the other houses, my grandfather owned the property. Mm-hmm. His house now has septic as well as my aunt's house, which was the second part.
Right.
So we've had septic, I want to say, I'm guessing, in the 70s, possibly, when septics.
So is it fair to say that you have a potentially right now a failing septic?
We did have it possible now, but while she was living and I was taking care of her,
right,
I had just gotten the septic cleaned.
Sure.
And it did pass. But for that area, my uncle is the only one that's still living.
Okay.
And the other families there.
How many families, I'm sorry?
I want to say it's about 10 to 15.
On your land?
These families are older.
Yeah. I understand that. I'm just trying to get an idea of
so
what systems you're on and how long
all of them are on a septic system. We have a septic system.
And so I just want to also then further ask about, and Delegate Naraki and Shalega, what the county, like how the county potentially has maybe attempted to work with the homeowners as well as the state to potentially plug in or not, because I know to a different, I'm sorry, Mr. Pro Tem Stein's not here to talk about it, because I know there is somewhat of a grant or program or loan program that the county can apply to get residents or certain places onto municipal and county systems. So I just don't fully understand the kind of the process.
Well, we have been working with Baltimore County on this. We've just run into a lot of roadblocks and hurdles. And we met Ms. Payne and her family, Delegate Naraki and I, just paint a picture for you. We're out talking to neighbors at that time of year when you're out talking to a lot of neighbors. And we find this gem, beautiful street, very tucked away. It's a historically Black community. And as we go door to door and talk to people, we're hearing more and more about, they're having trouble with their failing septic systems. They've been there since the 30s, and the infrastructure is just gone. And so one of her neighbors is this sweet lady. She's 99.
Just turned 90. My aunt, before she passed away, she would pass away at 90. So it is an older
Yes,
historically
understand.
black community. Most of the houses there are older. And we were offered some of the things that it wasn't going to work for that particular neighborhood because of the age of the people. The
Sure.
homes are older.
Sure.
And then we was promised the septic system in the 1970s. It just did not happen.
So I guess, let me ask, I guess, a better clarifying question, Delegate Naraki and Delegate Shalega. How many other spaces in the county have this somewhat very insulated issue where, to a degree, we can call this an environmental justice issue, right? Like you've got these smaller communities that are out of touch. How many other communities like this, with this issue, is in your district or in the county?
Yeah, Madam Vice, so I can definitively say that, one, we've already addressed one community like this. So this is actually the second time that I've seen this issue, and that's kind of what was the genesis of this bill. There was another community in the Perry Hall area. Senator Klausmeyer at the time, now county executive, was able to secure funding to help that community link up. But I know of several other communities that are in this circumstance in our district that are, again, not in the critical area, but are still on septic systems that also are having some of these kinds of issues. You know, our district is very low-lying and very wet, and, you know, when you have these, like, really wet areas, septic systems can, you know, tend to fail in those circumstances there. So I know that there's at least a handful more in our district, and I'm sure there's probably some others around the state.
Understood. And I just want to also point out the MDE's letter about undermining Maryland's comprehensive planning and smart growth policy, the septic to sewer, and then talking about potentially some of the issue may be that the moving to a sewer system may not be a system that is fully upgraded yet, so it may kind of compromise maybe some of the, but I mean, certainly would love to talk more about this, because if there are more areas, maybe there's something we can kind of work on.
And Madam Vice, if I may, that part of the letter there, and we've had, MD and I have had many subsequent discussions, that was really targeted at this Richland Manor wastewater treatment plant, and it's actually the only one of these sort of community wastewater plants left in Baltimore County. I think that MD and I have kind of could get beyond that by just changing some language there inside of the bill.
Okay, I do not see any further questions, so thank you. We have a favorable amendment. Witness, Edward Harrison, Maryland On-Site Wastewater Professionals Association, and just for efficiency, let's also bring up our unfavorable, Emily Ransom with Clean Water Action. Go ahead when you're ready, sir.
Good afternoon, Mr. Chairman and members of the committee. My name is Eddie Harrison, and I'm the legislative liaison for Maryland On-Site Wastewater Professional Association. MAP is in support of HB 24 with amendments. I want to thank the sponsor, Delegate Naraki and Delegate Shalega, for bringing this bill forward. The BRF grant has become, and I could tell by their testimony that BRF grant wasn't mentioned, but it was mentioned in the actual bill. The BRF grant has become a vital tool in remediating failed septic systems on difficult properties in the state of Maryland. The BRF grant program could use a little massaging to prove its effectiveness. The BRF program is divided into two pools of money, the public sewer side and the septic side. Okay, people that are on septic pay $60 into the septic side. The people on public sewer pay $60 into the public sewer side, nicknamed the flush tax. The public sewer side has reached many of its goals, but not all. Like he mentioned, most wastewater treatment plants have been fixed, but they have other goals they have to do. The goals for the septic side have got a long way to go. MALPA suggests that when utilizing public sewer connections to remediate a failing septic system, that the funds are taken from the public sewer side, not the septic side. This specific project that they're referring to is estimated to be $2.5 million to $3 million to do. That's what I was told by Mr. Naraki. But Baltimore County only receives $2.5 million for the whole year for the BRF funding for septic systems. The amount of money available to the sewer side of the BRF fund is substantially higher, that the money available in the septic side, then the money in the septic side. There's a substantial backlog of failing systems in the state of Maryland. Repairing these failing systems is vital to protect public health and the environment and protect property values. We suggest the amendment is to pull the money from the sewer side instead of the septic side, and I request a favorable report. Thank you.
Good afternoon, members of the committee. I am Emily Ranson with Clean Water Action, and while we appreciate the need for this bill and that something has to be done about neighborhoods on failing septic systems, we are opposed to House Bill 24 because it is looking to connect new sewer lines to non-compliant wastewater treatment plants. We are opposed to the precedent of approving that type of move, and we certainly hope that the state and the sponsors and everybody can find other solution to solving this, because this is a problem plaguing communities around the state. We have to do something, but adding more pollution to wastewater treatment plants that are not treating the nutrient pollution adequately should not be the solution. So thank you.
Delegate Lehman.
I do have a question for the last witness. So I just want to understand, right now, the state law, as I understand it, is that if you have a failing septic field and you are within close proximity to a municipal sewer system, you must hook up. You have no choice. Is that not true?
Yeah, it's written in there, yeah. Yeah, basically, yeah. But every situation is a little bit different. But yeah, if you're within hookup distance, you're supposed to. But I've got situations where they didn't. So I've seen it, heard about it.
So that's why I'm not understanding of your opposition. If most of the time, let's say you're required to anyway, then I don't understand the basis of your opposition. I know, I just want to say, I live in a house built in the early 70s in the northern tip of Prince George's County, and I have a septic system. We thought our field was failing a few years ago, and we were told you must hook up to the tune of, it was going to be like, and this was probably 15 years ago, $30,000 or $40,000. So how does your opposition square with what the law already says?
So our problem is that what is new is being able to hook up to a non-compliant wastewater treatment plant. So these are the ones, so like currently, the plant has to either have the enhanced nutrient reduction or be committed with a financial agreement that they are going to be doing it. And this bill opens that up so that the ENR does not yet have to be done.
Okay, one last question, Mr. Chair. So I understand your point, but if that's the case in the example that we have here of this community where these septic fields, are or may soon be failing, then what is their option then? Because they can't put in under state law, they can't put in a new septic tank. Is that not true?
So I don't know exactly in this particular if they would be able to do something like community septic, or if they would be able to do something like, going to sand mounds or other different types of septic systems.
I think there needs to be an answer to that question, because I think those are real life scenarios. It is certainly where I live. Thank you, Mr. Chair.
Any additional questions? Okay, thank you. That concludes the bill hearing on House Bill 24. We'll now turn to House Bill 338. Delegate Lehman, State Buildings and State Highways, Collection and Disposal of Yard Waste. Great. Thank the Maryland Recycling Network and the Department of Natural Resources. Is Chaz Miller still here from the Maryland Recycling Network?
You want me to come on up?
Yeah, if you're,
Sure.
Yep. And Department of Natural Resources? I heard they're a little short-staffed over there now.
Good afternoon, Chair Corman, Vice Chair Boyce, and my wonderful esteemed colleagues on the Environment and Transportation Committee. I am asking for your favorable report on HB 338. This is a bill that the committee and the full House approved last year, prohibiting both state employees and contractors from using single-use plastic bags for yard waste when working on improved state lands and along state highways. The bill was not voted on over in the Senate EEE committee. So the legislation would apply to yard waste collection around a building or structure owned by the state or built for lease by the state. That includes colleges and universities, as well as land around public mass transit and rail stations that are supported with state funds, and improved areas in state parks and state recreation areas. So in place of single-use plastic bags, the bill mandates that state employees and contractors have to use either a compostable container, like a brown paper yard waste bag, or a container that would not be discarded with the yard waste, such as a reusable bin or other type container. The bill I'm bringing forward to you now does have two changes from last year's bill. First of all, it incorporates the amendment that DNR asked for last year so that there is an exemption for state agencies to use black plastic bags for very specific scenarios where they're either noxious weeds or invasive species. We learned last year that these black plastic bags actually prevent those weeds or invasive plants from potentially propagating and spreading seeds and pods. The second change to this year's bill is it takes it one step further and actually now would require the yard waste, whether it is bagged or unbagged, to be disposed of at either an organics recycling facility, a natural wood recycling facility, or a state facility with on-site capability to create mulch or enrich soil. The Department of Environment has confirmed with me that these facilities around the state do have capacity for the disposal of yard waste. So the bill reduces our reliance on single-use plastic bags, which obviously are a major source of pollution, just like those plastic bottles that Delegate Ruth talked about. And then with the addition of requiring now that yard waste be taken to composting, organics, recycling, or mulch facilities, it will help us move toward our zero waste goals and rather than sending yard waste to landfills and taking up space that's meant for waste that can't be sent anywhere else. 1/3 of Maryland's counties have similar policies for residential yard waste pickup, and I believe it's time for the state to operate under those same standards. I think this is actually a little bit better bill than last year with that disposal language. There is no opposition, and I urge a favorable report. Thank you.
Yes, again, I'm Chaz Miller. I chair the Maryland Recycling Network Legislative Task Force. Our members manage many of the local government yard waste collection and composting programs in Maryland, and we were delighted to see the bill when it was introduced last year. Testified in support. We had an amendment accepted. Sorry we have to come back again, but we would love to see this bill come out. It's a win for Maryland. The most recent waste and recycling report from MDE showed 417,000 tons of yard waste were collected and managed at 21 permitted composting facilities operating in Maryland counties. This is a tremendous success story. I mean, this is waste reduction again at its best. It's keeping stuff out of disposal. It's creating a viable product for it. Adding yard waste collected from state-owned properties, including highways, will only add to our success in composting yard waste. And so obviously we urge the passage of this legislation. This is just it's a great win for the Maryland environment.
Terrific. Any questions on this bill? Okay, I do not see any, so that concludes the bill hearing on House Bill 338 and all our bills for today. Colleagues, just a reminder or a warning, we're going to vote in full committee after floor on Friday. So plan to be here for a little bit after floor on Friday. Hopefully we'll have a short floor session, meet, vote, and everyone can get out of here in the afternoon or go back to your offices and do work. But just plan for that for Friday. And subcommittee announcements on behalf of Delegate, he's back, Delegate Stein.
Thank you, Mr. Chair. The Environment Subcommittee will be meeting on Zoom at 5:30.
Delegate Holmes.
Thank you, Mr. Chair. The Housing and Real Property Subcommittee will meet at 5 p.m. via Zoom. Thank you, Mr. Chair.
Okay. Any other announcements? Okay, thank you all. Have a good rest of your afternoon.